We can start. Welcome everyone to this event on the independent ethics body for the European Union. Welcoming you on behalf of the 4 MEPs that are jointly organizing this event. So we have Giuliano Pisapia from the S&D, the Social Democrats, who is a member of the Constitutional Affairs Committee, AFCO, who is here, one of the shadows. We have Leila Chaibi, shadow for the United Left, GUE, also the shadow from the AFCO committee. I'm not sure if Stéphane Séjourné is here already, but he should join us shortly. He is the rapporteur in the Legal Affairs Committee, the opinion rapporteur in jury for the Liberal Renew Group. I myself, I'm Daniel Freund. I'm the rapporteur from the Greens, also Constitutional Affairs Committee. First, a technical note for all of you. You should be able to see at the bottom underneath the picture a button for interpretation, where you can select if you want to hear this event in English, French, or Italian, which is labeled by Zoom as Spanish, but there is an Italian translation channel available. So if you want to listen to the translation, it only works in the app, but at the bottom of the screen, you should have the button for that, and you can select your channel. If you have any trouble with that, you can always write in the chat, and someone from the team might be able to help you with that. I'm also very happy to be able to welcome Vice President Vera Jourova from the Commission. Thanks for being here. I'm going to do a quick introduction to the general topic and then give the word to the Commissioner before we go into the study with Alberto Alemanno, who is also here, law professor from HEC in Paris, who has worked on this topic as well. So I think we can start by saying that the European Union probably has better ethics rules, better transparency rules than many of the member states in the European Union. So on things like lobby transparency, on conflicts of interest, on revolving doors, there are reasonably good rules. But they are not always very well implemented or enforced. We have seen over the last few years a number of scandals that I think have highlighted some of the weaknesses in the system. Maybe most notably, there was the case of former Commission President Barroso, who joined the investment bank Goldman Sachs after leaving office. But he was not alone from the commission that left in 2014. There was also Nelly Cruz as former digital commissioner who joined Uber, and actually over 50% of the commissioners then that left have joined organizations that are on the EU lobby register. For members of the European Parliament, those that have left, over 30% also joined organizations on the lobby register. One of the more notable cases there was the former chair of the Economics and Monetary Affairs Committee, who a couple of months after leaving office joined the London Stock Exchange as lobbyists. But not only for the high-ranking politicians, we have also seen cases at the staff level, so the EU civil servants. One particularly outrageous case that I found was someone who joined the European Commission from ExxonMobil, then went on to work in DG Energy and was responsible for the relations with the OPEC countries, then went on a sabbatical from that position to become the European chief lobbyist for the Saudi Aramco oil company. So revolving in and out of the institution with lots of risks for conflicts of interest. Also, another example is Adam Farkas, who was the head of the European Banking Authority, and then without any break, joined the Association of Financial Markets in Europe, so the lobby organization of the banks that he most recently regulated before joining them. In the European Parliament, we have seen that our own rules. The code of conduct has been broken at least 24 times in the last couple of years, and not a single one of those breaches has ever been sanctioned. So there as well, even the rules that exist don't necessarily get enforced, and this of course is a problem for citizens' trust in the EU, right? These questions are about the functioning of our European democracy. It shouldn't be the case, obviously, that lobbyists write their own law, or that money in any way can buy decisions or influence with politicians. And I think in a situation where we, the institutions, have just approved the next 7-year budget and a huge Corona package with Next Generation EU, so we're spending more money than ever. I think in that situation, it's particularly crucial that the decisions on how and where this money is spent is in the general interest, and that special interests, individuals, cannot shape those decisions in an unduly way. Otherwise, I fear we fuel populism and Euroscepticism. And I think I'm very glad that we have several representatives from France here today, because I think the French example is a particular one where we have seen over the last few years how a new body, the High Authority, has started working in this area, and I think has really changed the culture in that respect. So very happy to be here today with all these key players, and that we can discuss the creation of the ethics body. But first, now I want to turn to the Vice President Jourova. Your commission, when you first joined the commission 6 years ago and a little bit, the commission stopped meeting unregistered lobbyists, and you, as commissioner, you were the first generation that published their meetings. You have also toughened in the last mandate your own code of conduct. You have prolonged the cooling off periods, and you just finished the negotiations on an updated EU lobby register. So that's quite a track record. Actually, before the European elections, all the Spitzenkandidaten that were running for Commission President pledged that an EU ethics body should be created, and Ursula von der Leyen, during her presentation to the European Parliament, made that same pledge, and it is now, of course, in your mission letter, Ms. Jourova, to create that. So very glad that you can be here today and speak a bit what your plans for this are.
Thank you very much, Mr. Freund, dear honorable members, dear Professor Alemanno, dear guests. I am very pleased to be here today with you and to open the event about the creation of an interinstitutional ethics body. And Mr. Freund, you are absolutely right. We need more trust from the people, but we have to deserve the trust. That's why it's only good that we have started already concrete steps. The transparency register was a very concrete achievement, which we gained before the Christmas time, and we have to continue the work on improving the culture and the trust which you mentioned, and some of the stories or cases you mentioned are just telling that it's not artificial, that it's a real life which brings these situations which attract the attention of the public, and we should be doing more to set the rules and especially to guarantee the implementation of the rules, so that we avoid not only the cases themselves, but we are able to react on the cases in the proper way. And indeed, as you mentioned, the President von der Leyen has expressed her full support for the creation of the body in her political guidelines, and also recently there have been many developments on this issue in the European Parliament. So I am glad that the things are moving on this issue, and this is a very good news, which I very welcome, also because indeed I have it in my mission letter that it's on my shoulders here in the Commission, and I will do whatever I can to achieve good solutions. So it's also a good opportunity for me to share with you the preliminary views on this important file from the side of the Commission. We support the creation of such a body because we believe that the institutions of the European Union must meet the highest standards of independence, integrity, and impartiality. Definitely already now we have higher standards than in many of the member states, but we should not compare ourselves with those who are behind us, but we should always seek for increasing the standards ourselves. Our institutions have a common mission to serve the general interest of the Union and need the trust of European citizens. Therefore, not only our decisions must be right and convincing, but also our behavior must be irreproachable and guided by ethical principles. Ethical behavior of staff and commissioners is of utmost importance for the Commission. Every unethical incident can endanger the whole reservoir of trust built over many years. That is why the Commission has developed a set of ethical values, principles and rules on the basis of the principles established by the treaties. The treaties and the new code of conduct for the members of the Commission adopted in 2018 constitute a comprehensive set of ethical obligations which ensure that the College of Commissioners acts in full independence in the Union's interest and for the public good. We are in favor of an interinstitutional ethics body which has a competence for the members of the institutions who are the political representatives of the Union. This includes members of the Commission, but also the members of the European Parliament and the members of other EU institutions. Bringing such competence into the remit of a joint body is also a question of credibility of this process, which must be seen as a collective operation for enhancing ethics at EU level in general. We all know too well that many citizens do not distinguish between different institutions, but see all institutions as the EU as a whole. This is why we must provide evidence of a true European culture on ethics. But the process for setting up a joint body has to be respectful for the particularities of each institution, as well as the respective institutional and democratic role each institution and its members have to play. In other words, the body should not replace, substitute, or interfere with the responsibilities and prerogatives of each institution. The body's role and responsibilities have to respect the institutional balance between the EU institutions as established by the treaties. And it will be important to ensure that the proposal to be tabled gets a buy-in from every single institution. Currently, there are significant differences in the approaches of different EU institutions. For instance, the Commission has an independent ethical committee with external independent members. There are a former judge of the Court of Justice, a former member and vice president of the European Parliament, and a retired Director General of the Commission. So this is the committee we have in the Commission. The other institutions, including the Parliament, have committees which are composed of current members of the institution. Therefore, when designing the body, we should take into account in our work the current practices and experiences in the different EU institutions. And we should also look at the various approaches in EU member states to ethical matters. Some member states, indeed, can be a source of inspiration for us. Looking at different approaches, both at national and EU level, will enrich our reflection and our discussions between institutions. All this is essential before making a proposal for the creation of the body. I welcome a lively debate on this topic, and I am particularly pleased that academic scholars study the various questions related to this idea from different angles and contribute to the debate. Academic studies like the study which Professor Alemanno will present today are an important contribution to a public discussion as well. The creation of a new body needs a careful assessment of the different options available and, above all, in-depth analysis of 3 points. The first one, the potential scope, role, and competencies of the envisaged body. The second is the legal basis for the creation of the body. And the third, the interaction of the body with the existing legal and ethical frameworks in the different institutions. Similarly, we have already identified 4 key parameters for setting up the envisaged body. First, the highest ethical standards must be met. The exercise cannot result for any given institution in lowering standards than the current ones. Second, the independence and accountability of each institution as set out in the treaties is of fundamental importance for our democracy at EU level and must be respected. Third, there can be no overlap or duplication with existing independent bodies like the European Anti-Fraud Office, the European Ombudsman, or the European Court of Auditors. And fourth, legality, fair rules and procedures, as well as expertise, independence, and an impeccable professional background of the members of the future body are a must for the body's credibility and of it. In my view, we will have to work on these and other issues in the coming months in order to achieve concrete progress. So let me conclude. I am convinced that the key to success in the undertaking is balance. While creating an independent interinstitutional ethics body, we need to respect the independence of each institution and its members. We need to promote compliance with high ethical standards while acknowledging that our European institutions, their members, and the European civil service meet already today high ethical standards and deserve the trust of all European citizens. I am looking forward to this discussion in the coming months, and I am confident that in the end, we will succeed. I am convinced that we will see the creation of an independent ethics body that will enrich the institutional landscape of the EU and that will bring the reflection and analysis of what is ethical behavior in a given situation to a new depth. Honorable members, dear Mr. Freund, thank you very much for your attention, and I wish you a fruitful debate today with many new insights. And now I'm very much curious to what I will hear from Professor Alemanno. Thank you very much.
Thanks, Vice President, for sharing your thoughts. And indeed, Alberto, we're very curious to hear your thoughts. You're, of course, in Brussels, a rather well-known figure. You apply politically your legal expertise. You have, for example, previously with a study, I think, given the harmonized whistleblower rules of the European Union quite a push. So you have looked in your study now at best practice examples from across the European Union, and I think beyond as well, and identified a bit how such an ethics body could actually look like, legally speaking. So the floor is yours. Looking forward.
Thank you, Daniel. Thank you, Ms. Jourova, for the kind introduction. It's a pleasure to be here today. Thank you for the opportunity, Daniel, and the other members of the European Parliament who are participating today. It has been a great opportunity to dedicate some of my research time to go a bit deeper into the European ethics frameworks that exist in the Union. And I will do my best in a pedagogical, possibly not pedantic way to show you what would it take for the European Union to actually set up a European ethics body. In order to do so, I would like to make a step back and to go back to some of the issues that were mentioned by Ms. Jourova and by Daniel. What is the European ethics system today? Where do we stand? And why it actually exists? If you look at the rationale, it's pretty intuitive, right? All public officials, regardless of whether they are elected or appointed, and their staff, they serve in the public interest. However, very often European officials, like any other public servants, they find themselves exposed to external pressure, and they might find themselves at the time of the exercise of their mandate in a situation of conflict between their private interest and the duties of their position. So the European ethics framework has evolved over time in a very scattered fashion, institution by institution, in order to prevent and mitigate negative consequences that might affect the European financial management, but in the long term also tarnish the European institutions' image and the European integration process itself. So when we talk about ethical standards, we actually refer to a variety of principles, values, as Ms. Jourova said. Those are essentially the principle of independence, integrity, confidentiality, and discretion, which are introduced and imposed on our members of Parliament, the Commission, and of course the staff through a variety of legal sources. Those are in the treaty, but also in secondary law, as you can see in a variety of legal documents. Not only the treaties, also the rules of procedure, the codes of conduct, they contain these provisions. This table is one of the first attempts at systematizing those rules and seeing exactly what kind of hierarchy do occupy in European law. The second question is, who is enforcing those ethical standards? And we already heard some illustrations from Daniel earlier on, from Ms. Jourova, saying that we have a variety of organizations, of bodies that institution by institution do provide a monitoring of the respect of those provisions. We have advisory committees in the Parliament and in the Commission. We also have appointed authorities and disciplinary boards, institution by institution, when it comes to the staff. We certainly have the European courts, which have an exclusive competence for the alleged violation of such of those principles. And then we have Olaf, which has already been mentioned, who has not only a competence in relation to fraud and to, let's say, illegalities that might affect the European financial interest, but also specific competence when it comes to serious misconduct in terms of ethical norms. So not of all of them, but just the gravest violations might trigger the intervention of Olaf. What sanctions are we talking about? Well, there is a possible taxonomy of sanctions. Some of them are reputational in nature. They are a reprimand, a warning that will simply leverage on social pressure in order to put an end to a behavior which is in breach of those principles. But some other sanctions, they go beyond reputation and they affect the position in an institution. Think about relieving from responsibility a member or a staff, deferment of advancement in career, denying the right to speak or exclusion. And we recently witnessed some of those decisions taken at the party political level, not at the institutional level in the European Parliament. We also see irreversible sanctions. These are situations of termination that might also occur in relation to a member of parliament. This could be decided by the parliament itself upon the initiative of the president or a member of the European Commission. And finally, also financial sanctions are contemplated and can be associated with those sanctions. So the question is how good this system is. You see how articulated it is, certainly scoring above the average of what exists at the member state level. And the Court of Auditors in 2019 happily concluded that overall the EU has a good, adequate ethical framework with some room for improvement, and one major issue which has to do with the Council, which has no mechanism for making sure representatives of the member state actually comply with those rules. But overall, this analysis seemed to be positive. However, there's a methodological annotation that has to be made. As the Court of Auditors says expressly, all the analysis by the court only focus on the law in the books. They only look at the standards. They didn't look at how those standards are applied, how are enforced, and what kinds of sanctions are actually adopted. In other words, the empirical dimension totally lacked. But when you look at the enforcement, and that's exactly what this report tried to do by interviewing a lot of key figures in the institutions and other academics who have been working in this matter, the image that emerged is very different. And this is certainly symbolized by some of the emblematic cases that Daniel mentioned. some former European commissioners, but also some former members of the European Parliament who managed to get away with a full compliance of those obligations. This is certainly the case of Rachida Dati, as you can see in this table, or Neelie Kroes, who merely apologized for forgetting not to report all this information before actually entering into the function of a commissioner. And when we look at the more recent emblematic cases, we also see situations, some of them were referred to by Daniel, in which there hasn't been inaction. As opposed to that, we could see the advisory bodies taking action, authorizing staff, for instance, leaving the European Commission, making this move out of the institution, either on a temporary basis, which is the case of Kruger, or on a definitive basis, which is the case of Sala, upon the compliance of certain conditions. But when you look at those conditions, how they've been formulated and the way in which they are today enforced, you could see they are unsatisfactory. It is pretty clear that there is certainly a perception and possibly a substantive violation of some of the principles I mentioned in the current circumstances. So a diagnosis of the European ethics framework that look empirically at how those norms are applied, they clearly show three major weaknesses of the current system. First of all, the system is fragmented, in particular in the way in which it is applied. The system is very weak when it comes to the enforcement mechanism, with absence of right of initiative by the advisory body themselves, by the absence or limited investigative power, with the sole exception of Olaf, which is competent only for serious misconduct, by leaving a very wide gray area of conduct completely outside of the scope of his own investigative power. And finally, there is, as it stems clearly for the European Court of Auditors audit, limited awareness among members, among staff about the existence of those norms and the way in which they're applied and their possibility to actually ask for advice before engaging into activities or into behavior that might actually raise issues in relation to compliance with those principles. So there's a bit of a lack of a culture stemming also from this study and this observation of the status quo. So to sum up, de jure, we have an adequate ethical framework we could potentially be proud of when compared with other experiences at the national level. But in practice, the system seems to fall short on its own mission to prevent and mitigate the most negative consequences by preventing and sometimes not adequately sanctioning major breaches and certainly having reached limited awareness. As mentioned by Daniel and confirmed by Ms. Jourova, in the mission letter, there's a clear idea, which is an idea that has been floating in the air for a few years now, to actually establish a European ethics body common to all institutions, or to most of them, in order to potentially overcome some of the flaws that I just described to you. This is not a new idea. In the framework of my research, I realized, thanks to a request for acts document I introduced to the European Commission, that back in the year 2000, a proposal was made by former Commission President Prodi, together with Neil Kinnock, to actually ask the European Parliament and all the other 7 institutions at the time to establish an advisory body that would have been competent for verifying the standards in public life. It's a very good template today, certainly less ambitious of what we currently need, but something that has unfortunately didn't see the light of the day because this proposal was never followed through by the Parliament and the Council, and was taken up by several civil society organizations, in particular Transparency International. In the meantime, very interesting, also the Council is suggesting the need to improve some harmonized frameworks when it comes to ethical frameworks. We see that the Council conclusion in response to the audit by the Court of Auditors clearly push towards the direction of a creation of potentially a European ethics body. So the question is, what sort of European ethics body can we envisage today? In the analysis that you will see in the report, I've been trying to identify, together with my research team, which I thank very much, a variety of instances and precedents, in particular the French haute autorité that has already been mentioned as an outlier in going certainly above the standards today, but also the British example, the Canadian example, and the proposed new public standards commissioner from Ireland, which has not been adopted yet, but has been proposed in significant terms. In short, when you compare our European ethic bodies existing across European institutions with these specific national experiences, you could clearly see that when it comes to the scope, the new normal among those bodies is to have a very wide scope, to have one centralized, one-stop shop authority that is competent to verify the respect not only by members, but also by staff. As you can see, there are a lot of green lights on the first line. When it comes to independence, you can also see significant autonomy by these bodies in relation to the executive or the parliamentary scrutiny. When you look also at the monitoring role, virtually all those institutions can actually take action. In the case of France, even civil society organizations do play a role in asking and in prompting the authorities to actually investigate and to potentially open an entire action vis-a-vis some members or staff. Same is true for the advisory role, same is true for investigative powers, and when it comes to sanctioning powers, also those authorities seems to be more consequential than the one that exists at the European level, where the sanctioning power remains limited and very much in control of the leading sources of those actions. The budget, the staff also reflect the level of ambition and wide scope of those organizations. So out of this picture and comparative analysis, one could sketch an ideal European ethics body, an ethics body which also works as a one-stop shop, which has a wide scope, which has a wide and broad mandate covering not only the respect of ethical standards, but also lobbying rules, transparency register. That's a reality in a variety of countries I share with you, and also an advice role. Right of initiative, enhanced investigative power, and possibility also to adopt orders. This seems to be what an ideal model should be able to do. But to what extent is possible to do so? Well, there are two possible ways, as already identified in the guidelines provided by Ms. Jourova. We can either rely on pre-existing European institutions by conferring extra authority, or we can set up a novel entity. So very briefly, there are three major candidates for a possible extra power: the European Ombudsman, Olaf, and the European Court of Auditors. When it comes to the Ombudsman, she already plays, because the Ombudsman is a woman, a non-direct role in the sense that is already verifying to what extent the institutions are actually applying the ethical standards by themselves. You might all remember the decision by the Ombudsman on the Barroso case, for instance. However, her authority by definition and statutory is not legally binding. It is very much relying on moral suasion, and one might wonder whether this is the kind of authority it is needed for this task. And in any event, a revision of the statute, which by the way is ongoing, is currently needed. When it comes to Olaf, it also played a role already. As we said, the director can open internal administrative investigations for the more serious misconduct. However, it doesn't enjoy direct power, but it relies on the member states' authority. And finally, also here, a revision of the statute would be needed. And finally, when it comes to the Court of Auditors, well, the Court of Auditors' main task is audit the use of European funding and not necessarily ethical matters. And also here, a revision of the statute would be needed. There are more broadly horizontal reasons that suggest that it might be wiser to actually think about an autonomous entity as opposed to attaching extra authority, because this organization might change their nature and might therefore be either watered down or excessively centralized in their authority. Therefore, I think that a novel entity would do a better job in actually pursuing the mission we have identified together. Three possible legal bases seem to be potentially able to be conducive to the adoption or to the creation of a European ethics body. The first legal basis is Article 298, which has never been used, introduced by the Lisbon Treaty, in order to allow legislative power to the institution through ordinary legislative procedure to set up open, efficient, independent administration. 352, flexibility clause, as you know, is a bit of a jolly, very often used in European integration when the competences are not explicitly granted in the treaties, but the institutions still need to act in relation to their mission and mandate. And finally, Article 295, interinstitutional agreement, which allows the institution to come together and to bind themselves in order to obtain and to reach certain common objectives. So 298, never used before, as I said. It is questionable whether it could be used for the setup of a European ethics body insofar as the members of the European Parliament or members of the College of Commissioners are not staff. They are rather elected appointments. So they might not fall under the notion of European public administration. That's what most of the literature seems to suggest. When it comes to 352, unanimity is required in the Council, but also the nature of this provision is exceptional. So is only residual. It's only when any other legal basis is not available that it could be relied upon. So Article 295, the possibility of having the institutions on a voluntary basis coming together in order to rely on their own procedural autonomy, so the competencies they already have, deciding to pull together and to share in the framework of a new body, the exercise of this authority would seem not to compromise any right, any obligation, and also to do justice to the Meroni doctrine, which basically creates and introduces limitation to the possibility of delegating the exercise of power. This seems to be the most promising when compared among the other legal bases, and in particular, the construct that one might envisage is the idea of having a basic arrangement among the institutions that basically entrust the respect of the ethics standards to this body. So it would be a combination of an interinstitutional agreement and an interinstitutional body. The body would ensure coherence, a coherent practice throughout all the institutions. And this is a major advantage of interinstitutional agreement. There are precedents, the European Personnel Selection Office, EPSO, but also the European School of Administration, the Computer Emergency Response Team. These are interinstitutional bodies which were created in such a way. As you can see, no legal basis as such is available to set up an ideal European ethics body. So even Article 295, even an interinstitutional agreement might not necessarily satisfy all our expectations when it comes to the ideal model we have identified, but it certainly go a long way to improve and complement the current ethics system. Apologies for the very dense slide, but this is the key slide of my presentation, and I'm very close to an end. With an interinstitutional powered European ethics body, we would be able to set up one single permanent oversight body tasked with the respect of ethics standards. The scope would be wide, not only relative to the members, but also to the staff, because the staff regulation already foresee a enabling clause that allow the outsourcing of some, the respect of some obligations, notably those in relation to conflict of interest through an interinstitutional agreement like this one. Article 2 and Article 9 both provide such a basis. It is important to also identify a limitation here. Not all the pre-existing staff disciplinary procedure would be substituted, but it would still remain for non-ethical obligation, such as the residence requirement or the harassment policy. These are issues that are not related to ethics and that would not be transferred to the body. When it comes to the composition, we can have an interesting conversation in the coming weeks and months, but the interinstitutional agreement might define a mixed model. And I think one of the most promising answer or solutions come from the authority in France, where you have a mix of political appointees with former members and with high judiciaries representatives all mixed together, and only the president of the authority being appointed by the French Republic president himself. When it comes to the enforcement, the important element is to imagine some autonomous monitoring capacity. And if you think about the potential of pulling together what is already happening, each institution already gathering all this information, financial declaration and others, and having them in a centralized register that this body would be responsible of, in a way in which the OI authority in France is already doing, and also leveraging on other sources, a European harmonized whistleblowing protection system, and potentially also third-party input, like civil society organizations being able to flag the issue to the authority. A right of initiative is essential, but this has to happen in synchrony with Olaf, who we see is and remain competent, and potentially after the current reform and the new interaction with EPO, will also continue to be responsible for administrative investigation for the most serious misconduct. Investigatory powers could also be transferred. It's important to remember that an interinstitutional agreement can actually allow the institution to transfer competencies which exist, but which have not been fully exercised. And that's exactly where more investigatory powers could actually be incipient within the body. And finally, when it comes to the sanctioning power, I think it's very important this idea of having for the staff the possibility of not having the appointing authority, but to having, with the enabling clause mechanism, the body itself being able to adopt those sanctions in the same way they do today, in a way which is in full conformity of the Charter of Fundamental Rights and guaranteeing all possible defense and due process guarantees. When it comes to members, there are limitations in relation to the nature of the sanction that could be adopted. So in the report, I refer to soft penalties in order to capture the reputational sanctions and those affecting the position, but they cannot go too far in adopting measures that the treaty only entrusts to the Court of Justice when it comes to the commissioner, or which the rules of procedure entrust to the parliament itself when it comes to members. I'm thinking about termination. All these decisions of the bodies would be judicially reviewable in front of the Court of Justice, and also be subject to the administrative control of the European Ombudsman. I'm coming to an end in order to highlight the added value that I think a European ethics body might actually bring to the European legal order and to the expectations, I guess, of citizens, and potentially also of the political class and the staff itself, to be in full compliance with the ethical standards. The first added value would be to close the gap between the ethics standards as they are written in the books and their actual enforcement. This is the weakness that we have identified in this report. And the way in which they would do so, pulling together existing competencies among the institutions through the creation of a single, permanent and independent body, would favor common approaches. And that's exactly what is happening now. Each ethic body is insulated from exposure to the administrative practice or even judicial practice of other oversight bodies. This might lead to potentially a new administrative culture, but also a new political culture, because inevitably the overall conversation around ethical issues would be centralized while taking in full consideration the diversity of the normative standards that each institution has. So the body won't change the standard. It would simply make sure they are better applied in a more uniform, consistent, and in possibly legally predictable way than today. Thank you.
Thanks, Alberto, for that very comprehensive presentation. I think that should be a good basis now to go into the discussion. Maybe as a quick reaction from me, what I take away of this for now, the drafting of the report that we're going to discuss then in the Constitutional Affairs Committee. I think when it comes to legal basis, indeed, I think your recommendation of an interinstitutional agreement is probably the sweet spot between, you know, allowing us enough of this ideal ethics body, yet also allowing us to do something still this mandate, right? If we could do more, I don't know, with treaty change, that might be something that that's a stretch to achieve in the next couple of years. We've seen how difficult that is in the recent past. I think also what you're saying in terms of the existing bodies and the advantages of in some form a new body, or if you want a merging of those bodies that exist within the institutions right now, right? The advisory committee, the independent committee in the commission, in a way pulling that together and allowing us to standardize or harmonize a bit the view on ethics, on transparency, on conflicts of interest. And I think, well, one of the key debates, Ms. Jourova has also mentioned it in her introduction, is of course the composition of such an ethics body, right? Who are the people at the end that will uphold the rules that that exist within the institutions? And there again, I think I agree with Ms. Jourova. We need to take care of the particularities of each institution. A lower staffer certainly should face different obligations for transparency and also integrity than a commission president or a member of the European Parliament. So you need somewhat different rules, but nevertheless, I think a common understanding of what is a conflict of interest, for example, or how certain rules among the different institutions for the same level of staff should be applied is useful. But then overseeing this, my idea so far would be that, for example, that you have 9 people in such an ethics body, 3 each nominated by the Commission, by the Parliament, and then by the EU staff that would be concerned. Could be an idea to sort of take into account the particularities and also the preferences of each institution. Actually, an idea that I got from Mr. Pisapia that talked about this in the past. And I think the last point I want to make here is what you said, Alberto, about the decision powers. That ultimately one of the key issues here is sort of the self-control of institutions that we've seen in the past, and that has created some of these issues we've seen in the past. So the closer we can get to the ethics body, not only giving advice and recommendations, but actually taking decisions subject to all the review that you mentioned, by the courts, by the ombudsman, possibly even by the institutions themselves, but that the first impulse comes from the ethics body, I think makes imminent sense. With that, let's go into the debate. First, I want to give the floor to Mr. Pisapia. Thanks for joining today. I think there's 2 experiences that you've had in the past that are particularly exciting in a way for this. As mayor of Milan, you had intricate experience with the Milan ethics body, and that's indeed where your recommendation of this 333 composition came from. And I think the second experience is that you're one of the 5 members of the current advisory committee in the European Parliament, where I think you have seen a bit over the last year and a half, maybe some of the shortcomings, and would be very excited to hear from you what your thinking is about the EU ethics body and what lessons to be drawn from your previous experience. Thanks for being here.
Grazie Daniel. Saluto a tutti.
Thank you, Daniel. Thank you for your kind words. Can you hear me? Yes, we can hear you, no problem. Thank you so much for your kind words, and thank you for having organized this event. It is the first event in which we discuss among different people, some people who've already met before about this, or some others who haven't. Thank you for your presentation, Mr. Alemanno, Professor Alemanno. You're really very ambitious, but the objective is very important. The ethics body devised by the European Parliament has some weaknesses. We all agree on that among the members of the committee. And Daniel, very often you say that there have been many infringements, conflicts of interest, but so far the European Parliament has not taken any sanction, given any sanction apart from a stance taken by President Sassoli. I also worked for the jurisdictional committee in the Chamber of Deputies. Well, you mentioned my experience, but there is a general experience. I mean, all people, we are all favorable, but sometimes there are some people who are not that favorable. So I think that we should really try and make the attempt to have a further decision by the European Parliament, a resolution, a decision or a position by the European Parliament that leads to a step forward than what we had in the year 2000, and that makes a progress vis-à-vis what the Parliament has done and adopted during this last period. Many resolutions, but no step forward. Well, thank you, Commissioner Jourova, for your speech. I would like to say very strongly that if we do not work together, the European Parliament in the lead committee and then in the Parliament and the European Commission, we will not make progress, and progress is necessary. We might not achieve the final objective, but we have to make some progress. Without being united in our intentions, without having a clear debate on the part of the European Parliament and the Commission, we will not have any progress. And Professor Alemanno is submitting many proposals. We'll then have to decide which is the possible decision that might not only be accepted by both Parliament and Commission, but the solution that might have an impact also on the other institutional subjects at a European level. It is maybe too early to say this, but according to my experience, we should tackle this immediately. Otherwise, we might write something that is very nice on the paper, but there will never be a tangible result. For instance, we could at the level of the advisory committee in the Parliament, we could make a step forward and create conditions so that sanctions are actually made effectively. I mean, because otherwise we lose our credibility with citizens. This study, the survey of Professor Alemanno, says something that I agree, and I suppose that most institutions also agree. We need to change. The status quo does not guarantee enough compliance to the ethical principles that the European institutions have established. However, and Vice President Jourova also expressed this, we have our shortcomings, but compared to some other national institutions, we are at a higher level. That is, we try to solve this problem, we discuss the problem, and we try to avoid some behaviors that are not very frequent, but that are important for the impact they have on the public opinion, and we try to avoid them. And we want preserve the credibility of the European institutions. For instance, the fact that Barroso, and I'm just mentioning this name because others have also violated the rules, the ethical rules. Well, you know, many citizens had put their confidence into him, and they were really shocked when they saw that someone like Barroso actually revolved the door and went to the other side. I mean, the person who was supposed to be the symbol and who was the symbol of Europe that could actually face social, economic, and rule of law problems. Well, they found that the European Union could not sanction, could not punish a behavior that was definitely not correct. And this fact that it was not correct is generally recognized. So, regardless of our political stances and positions, I think that we should really take actions in order to reinstate the faith, the confidence of citizens, and then the resolution that will approve and that in the AFCO committee will then submit to the plenary, I propose that there are three levels. The first level is that of an institution or a body that is for all EU institutions. I mean, a regulation, a proposal. Well, the situation is so complex that I think that it's even more difficult than it was in the past. So let's consider three levels. If we could, this is the other level, if we could do two things. The first one is to change the current advisory committee of the European Parliament, because I think that that would have the approval of all MEPs. That would give them the possibility of knowing the reality better, and through Olaf, we could have better investigations and have certain sanctions. And on the other hand, and I'm not moving backwards because I do believe in what you've said. Well, but anyway, I think we should have a B strategy. That is, this decision, this joint decision, could start with this meeting that we're having today or in the past. Well, so the idea with that of creating an ethics body or an ethics committee that becomes real and that is favorably welcome by both the European Parliament and the Commission. If this new ethics body or ethics committee can actually do some steps forward and show that it can operate and punish when necessary, it will then become autonomous, and automatically the other EU institutions will be part of it. Some diffidence is probably the first reaction, but it could be overcome. So, a very last consideration. You said that we've met in the past and we had very nice discussions. And today's webinar is even more interesting, I think, because there are other people here. The fact that an advisory or a more operational body is composed one third by, if there were an agreement between the various actors, we could have three members appointed by the EP, one third by the Commission, and then one third, that is the president included, could be nominated by the Court of Justice, so that we would have guarantee of independence. That would be a great signal of transparency that would send and will certainly improve the credibility of EU institutions, not only internally but also externally. Well, according to the Eurobarometer, only half of the EU citizens say that they are confident in EU institutions. We have to restart believing in the EU, and we have to remedy our mistakes by showing that something tangible has been done in order to achieve the final objective that we do believe in. I would mention Voltaire, who said that the best is an enemy to what is good. And I think that going through what is good will lead us to the best possible solution.
Thanks. The next person I have on my list is Stéphane Séjourné, who thanks so much for jumping in for your colleague at such short notice. Thanks for being here. As I said, you're the jury rapporteur, but you also know from, well, being a French MEP, you're not only subject to some of the rules here in the parliament, but also the high authority in France, where you have to submit a separate declaration where they look into what you have done and so on. So maybe you can, well, not only give us your thoughts, but also maybe the experience from living under the surveillance of this new high authority. Thanks for being here.
Merci beaucoup, Daniel. Merci pour avoir organisé.
Thank you, Daniel, for having organized this meeting, and thank you to Alberto Alemanno. His report has been extremely detailed and very interesting, so I would like to thank him. And I do agree with you because, you know, I'm double-checked, double-controlled, sort of saying, due to the control at French level, with which is extremely effective. You know that the high authority in France is really a success in terms of transparency. I would like to recall that the organization was set up in difficult moments with political financial scandals, and so the European point is extremely important because we need to go ahead to progress and to go beyond scandals and potential scandals. So I think that now we really trust that it is important, and then we know that the transparency is fundamental in this context of political crisis. So transparency leads to confidence, to trust. I think that now everybody is suspecting about politicians. So, you know, when we have transparency, then transparency helps politicians to really make their thought and their word more confident. So this body, this European body, with regard to this European body, I'm quite favorable. I'm really favorable, and I think that following the French example, that would be important in order to enforce the existing rules. There are several existing rules at European level. You have all these references, you know, with the several committees which already exist today. So there is also a definition of all the scope, and this exists, and also as in France, there is an enforcement which shall not be based any longer on a relationship of political forces, but I think that we need to have the same consideration without playing on the political relations and relationships. Because, for instance, I am really new as a parliament member, and one of the first political exercises we did was the conflict of interest of European commissioners, and I saw that that was settled, sort of saying, in closed hearings, so there were no there was not the transparency, there were no journalists, so there were this conflict of interest. There were some people who say that in Google they say so, etc., etc. So it was not a work which could be acceptable for the European Union and for us parliament members. So certainly there is something that we need to do. I think that independence is very important. I think that we need some members who are really irreproachable. But in any case, I think that each institution has references to appoint them. So the quality of members must be imposed to each institution. And as Alberto said, it is important to really leave the entire arbitration to the Commission or to European Parliament, to the Ombudsman, to appoint the college members. Yes, provided that they are qualified, they must be irreproachable, they have to submit themselves to a number of rules. So we need this interinstitutional agreement. And then there is another important point, because the French High Authority is an accompanying administration and not a sanctioning administration. And so, Daniel, I think that we'll manage to convince our colleagues, our European colleagues, in this way, and this is going to protect us, because including errors and mistakes that are not manifest or voluntary, intentional errors, but in the errors, the mistakes that a number of administration people could do. And also the fact of not being aware of the rules, not knowing the rules, this is important as well. So I think that when they make their declaration of interest, so it is important to correct a number of mistakes or errors. For instance, do I have shares? I hold shares. Do I need to sell these shares? Which is the mechanism which should protect me from a conflict of interest in relation to the companies I worked with in the past, etc., etc. So I think that it's sort of accompanying administration, and then also the sanctions are important, but in my opinion, the accompanying element is extremely important. And then last point, with regard to the French example as well, the check, the control is made before, in the meantime, and after. So I think that the definition of conflict of interest is requires the importance of the situation after, because for instance, if there is a politician who has got certain responsibilities and so can give or provide the private bodies or private companies with a certain know-how. So this is no more a barrier to the entry of a politician, but there is personal enrichment and also the fact that afterwards you get a certain know-how, a number of set of information. When you are Parliament commissioner, you have a set of information available that you know about, and then that information is extremely important and for companies in general, and also for administration, heads of administration, also in ministries, for instance, these people are really sought for, and exactly for this, exactly for information, the fact of having a knowledge, a lot of information, and so. Thank you so much for having organized this meeting. Thank you.
We're going to go to our last speaker, Leila, but already the invitation to everyone, raise your hand if you want to intervene afterwards and ask a question or comment anything here. You can, of course, if you don't want to intervene yourself, also write comments in the chat. Leila, your background is the fight against poverty.
Bonjour.
Social injustice, yes, and I think.
C'est OK, on m'entend bien?
Oui.
Can you hear me? Good morning. Good afternoon, sorry. Thank you, Daniel, for having organized this webinar. And I would like to thank Mr. Alemanno for his report and his presentation. It is very interesting, and in our case, because we are studying this opportunity. I'm sorry, but there is an echo, which is quite a problem. There is an echo. I'm sorry, there is an echo. With regard to the evaluation of conflict of interest and sliding doors within the European Union, there are those who work on this issue, and also in the case of parliament members, have knowledge, information, and I believe that they sometimes are considered in a different way. So there is a large consensus with regard to these politicians. So it is no longer possible that conflicts of interest or problems of ethics are examined within the institutions in which they have these people have worked. So your analysis is extremely detailed. We understand the difficult role in which these ethics systems are concern every institution in order to envisage sanctions as well. The solution is the creation of a new ethics body which may outsource this work, so to get out of the institutions concerned in order to have only one body which is common to all European institutions. I think that we all agree on that. So we wanted that this body is independent and effective. With regard to independence, I believe that the issue of independence is strictly related to the issue of the composition of this body. Body is independent and external, then the members must be independent. People not be in a situation in which they can be inquired or investigated about their conduct. So I believe that during in the commission we have worked about it, and with regard to the composition of this body, the independent ethics body, rather than considering one-third, 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 we would say, why wouldn't we find people from Olaf or Court of Justice or Ombudsman or also the civil society? Because if we look for the members only with the Commission Parliament, so once again, it is difficult to be you have to inquire, investigate about your own colleagues, because that would be quite complicated, in terms of independence. Then, with regard to sanctions, Mr. Alemanno, in his study said how to enforce or apply sanctions. The only way to have all ethics rules respected are sanctions, soft sanctions or stronger sanctions. So when there is the breach, then it is important to have also the sanctions. So the effect of sanctions and the fact that the sanction has a power of dissuasion, that is to say, a preventive power. And in my opinion, this should be considered. With regard, as it has been mentioned, there's several different legal options for the creation, for setting up this body. I think that, well, relying on a body which already exists, okay, but I think that the option, the better option would be to set up a new body. And it is obvious that, and this has been already mentioned by Daniel, you said that the modification, the amendment of treaties, requires quite a long time, and it is interinstitutional, yes, but we should not have the two things opposing one another. I think that if we have an interinstitutional agreement, and if this allows us to set up an independent body, ethics body, fine, but we should go beyond that in order not to find ourselves in a situation in which only the institutions of the most virtuous institutions are a party in this agreement, to this agreement, and then the others don't. So in order to conclude, I think that we should work in order to have an effective ethics body, and I think that all the people who are going to participate in this work, it is important to consider the conflicts of interest, considering ethics. This is not something optional. It is not an attempt or something that has to be done from time to time, but it is something which is essential, fundamental, in order to have citizens, European citizens, appreciate the European Union based on transparency of the people who have been elected by the citizens. Thank you.
Open the floor to questions from all of you. You can simply raise the hand with the appropriate button, or you can write your questions into the chat. First person that I have here with a question is Dr. Antonietta Elia. Now you have to unmute your mic, and then you should be able to ask your question.
Hello, can you hear me?
Yes, perfectly.
So first of all, thank you to convene that meeting, very interesting meeting. I would like to express my gratitude to Professor Alemanno for his presentation, and to and extend my gratitude to all speakers. Just very quickly, I'm professor of law from University of Santiago de Compostela. So I would like just to stress a few points about composition of the committee, which is very interesting to me. The form of selection of the members, and the question in relation to independence of members is also relevant to me, because if 1/3 of members will come from each institution, I'm not sure that independence can be guaranteed, especially if 1/3 of members still maintain their mandate in each institution. And the other point is very important, and I think that Mr. Sejourné underlined such a kind of point, is the question of the definition of conflict of interest. So to have an institution, possibly we just need also a shared definition of conflict of interest. What is the idea and the definition, the content, the normative content also of conflict of interest in a very broader sense. And the other point that I would like to receive about that, the views of the speakers, is the impact that the position of European Union institutions can have at national level, especially to those countries where no agreement exists about definition of conflict of interest. I think, for example, let me do reference to my beloved country, Italy, and possibly it can have a positive impact on the reasoning on or the debate and possibly the creation of a national institution in such countries. Thank you very much.
Thank you. We're going to take 2 more questions, I'd say, and then do a round of replies. The next person that would like to ask a question is Ulrich Petzold. If you can unmute your microphone. You have to click that on the unmute button, and then you should be able to ask your question. That doesn't work. We go to the next person on the list, Vitor Teixeira.
Does it work now?
Yeah, now it works. Great.
Oh, sorry, I just had a question to the professor when he spoke about the possibilities of Olaf to have investigations also for internal misconduct. When I look into that regulation establishing Olaf, I only see things against the financial interests of the European Union. So where does that mandate to look also into other misconduct come from? Thank you very much.
Thank you very much. And then now to Vitor Teixeira for the third question of the first round. Vitor?
Hello?
Yeah.
Can you hear? Perfect. Yes, hello, my name is Vitor Teixeira. I'm a policy coordinator at Transparency International EU. And I have a comment, not really a question. So, well, first I want to thank you, Daniel, and the MEPs for organizing this event, Professor Alemanno for his excellent study, and the Commission for including the creation of this body in their political guidelines. I mean, TIU is happy to see that the creation of this body is being discussed. We have advocated for this body for a very long time. We have long identified a number of existing weaknesses in the current ethics systems at EU level. Now, why I'm making this intervention is that we believe that the #1 issue to address is the weak enforcement of the rules. And we believe that much of this is due to the current system of the peer sanctioning self-regulation. And to address this body must, and this has been mentioned several times, we believe it must be truly independent. And that means in terms of members, of staff, of budget, but also have the power to initiate investigations on potential breaches and the ability to pass binding sanctions when it is necessary. We also think that it's an excellent opportunity to address the existing fragmentation. This has also been mentioned by Professor Alemanno and several other speakers. And we believe that, so we're supportive of measures to end this fragmentation. So replacing the existing ethics committees, we think it's essential. Harmonize the rules and the definitions, include both officials and EU staff. But it's also true that this body needs to work in a complementary fashion to other oversight bodies. It has been mentioned, the Ombudsman and the OLAF. It would be a shame to see these overlap. But at the same time, it should also work very closely with other units that right now in the institutions work with ethical issues, or in terms of lobbying the secretariat, the joint secretariat.
Thanks, Vitor. Maybe we start the round of replies with Alemanno. The most direct question was directed to you, and then the others can intervene if they want to. Alberto.
Thank you, Daniel. I found it very fruitful to receive so much feedback in a matter of few minutes after working on this for over a year. I feel in good company. That's a nice feeling. Thank you to Daniel. Thank you to Mr. Pisapia, Stefan, Leila. It's nice to see almost bipartisan support. At least many political forces seem to suggest that this is the time to break the impasse, what we define the impasse, the fact that status quo is no longer satisfactory to address the mounting public demand for different political behavior by members, but also by the staff. Interesting to see how much attention the issue of composition is drawing. I think it's legitimate to spend more time on composition. And when I try to connect the dots, thinking about the proposal by Mr. Pisapia, which, by the way, reminds very well the original proposal in the year 2000, in which each institution, each of the 7 institutions would have elect his own member, seems to be interesting, reasonable when it comes to 7 institutions. When it comes to 3, I partly share what Professor Antonietta Elia has been sharing, right? The importance of ensuring some more diversity, and that's why the study take the liberty to suggest a more mixity in the background of the members, and refers also to the possibility of having de jure former president of the Court of Justice, president of the Court of Auditors, in addition to the possibility of having the 3 institutions to actually designate their own members. So it is possible to blend them. What I found it very interesting in this model is the potential to mitigate and perhaps even neutralize the kind of partisanship that in the current application of the rules, in particular within the parliament, is impossible to overcome. So composition is scheme to somehow overcome one of the nature or inherently limitation of the current system. The second and last point has to do with the normative contents of the standards. If this body will emerge common to 2 or more institutions, perhaps initially the Parliament and the Council, as Mr. Pisapia suggested, but then be open on a voluntary basis to other institutions joining along the way, well, inevitably, the fact of interpreting those rules will create an administrative practice that at the moment is not visible, because many of those decisions are not accessible to researchers, to the media, and therefore this will be a major added value in hammering down the normative contents of this procedure. And I agree again with Professor Antonietta Elia when she said that at the end of the day, the EU has a unique opportunity to establish itself as a model for many member states, and therefore also to have best potential practices. Finally, Wolfgang Petzold asked me about the legal basis for OLAF already being competent today. Well, this is Article 2, letter B of the decision setting up OLAF, which refers to investigate serious facts linked to the performance of activities which might constitute a breach of obligation by officials and servants of the community, and as well members of the institution. So this is the legal basis for the director of OLAF already opening administrative investigation. And this is a competence which is there to stay because, as you know, OLAF has been shrinked as a result of the creation of EPO. So potentially more resources might exist in relation to the discharge of letter B of Article 2 of the decision I'm going to mention the number of the decision to be complete, decision 1999-352.
Thanks, Alberto. Giuliano, Leila, do you want to react to any of the comments, the debate we've had in between? Go ahead, Giuliano.
È ancora più interessante questa discussione perché entriamo...
Well, this discussion is increasingly interesting because it's very concrete. I really like the idea of defining, have the competent committee define the concept of conflict of interest, because the case law is very vast, and we need to define both the guarantees that are to be granted and also, for the sake of citizens, we need to have something shared here. And the second point is sanctions, which is key. Without sanctions, you're not credible. Sanctions can be a deterrent, because if a person knows that investigation might take place, sanctions, punishment might also ensure, and the bad reputation could be another consequence, you have deterrence. And there is another element that is very interesting. That is, in Italy, we had a tangible experience. People who receive some help to be rehabilitated and reintegrated after indictment, you have a relapse level that is 20%, whereas if you're imprisoned, your relapse level is 80%. So if you're helped, sanctions plus help is much more effective than just sanctions. The third point, well, we should always keep that in mind. We have our different opinions about the body composition, but EPs, European members of parliaments, need to vote. So member of parliaments need to be represented. But at the same time, there will be resistance. No one would say, I do not agree, but, some will say, I do not agree, but I don't want to be judged either. So we have to find a solution so as to guarantee for those who are might be under control that, the guarantees are there. And then you need to have a level of independence that is the highest possible. And also having nominees on the part of the Parliament or the Commission does not lead to the risk of indicating friendly people, indicating people who are friends, because you have different stances within the Parliament. So a mediation is necessary, and I think that the same applies to the Commission. Thank you so much for what the experts have said. Thank you.
Thanks. Leila, you want to intervene? Otherwise, I would take a second round of questions.
Tu peux prendre un deuxième tour de questions, Daniel.
Yeah, you can proceed to the second round of questions. Go ahead.
Okay, the first one I have on my list is Helen Derbyshire. Helen, yes.
Thank you, Daniel. Can you hear me?
Yes.
Wonderful. Good afternoon, everybody, and thanks for this very interesting debate. Helen Derbyshire from Access Info Europe. I'm also the chair of the Civil Society Coalition around the UN Convention Against Corruption and on the steering committee of the Open Government Partnership. And I have two comments. One is on the role of this body. Just to underline, I think it was some of the speakers mentioned this, but particularly Stéphane Séjourné, the combined mediation and sanction role. That seems to be something that's very important. And based on experience of similar bodies, both on questions of sort of ethics and integrity, but also in other fields, such as transparency, which I work on, having that mixed role is important, but the sanction role is, the sanction component is absolutely essential. And it's something that clearly we're seeing with the kinds of problems as Professor Alberto Alemanno highlighted in his excellent presentation. We've got the rules, but they're not being fully respected because there isn't, the consequences aren't there. So I think that the sanction dimension is really important. And the second point I wanted to make, again, drawing on much experience from elsewhere, is about the composition of this future body and its independence. And I do think that there's two keys to ensuring a body's independent. One is who the actual members are, and the other is how they're selected, because it's the independence and it's the perception of independence. I would say just 3 representatives from each of the main EU institutions is not a sufficient solution to achieve both that real independence and the perception of it. I would recommend, based again on good practice and experience from elsewhere, that there be some kind of open selection process, maybe with hearings, so that members of the public, civil society can follow that process, understand who the potential future members of the body will be, and so that it has a certain distance from each of the institutions which it's overseeing. And to that, I'd like to address something that Vice President Vera Jourova mentioned, a concern it sounded like she had, which is the need to maintain the independence of each of the institutions that this body might be overseeing. And I see a potential issue there, but I don't think it's necessarily a problem. The mere fact that institutions, public bodies have independence in doing their work, and that work should not be interfered with, having oversight that is itself independent, genuinely independent, of compliance with ethics rules doesn't undermine in any way the independence of those bodies. And I think that that's something that we need to, an issue we need to address head on. An independent oversight body isn't per se an infringement of the independence. So I think that those are having a genuinely independent body with decent powers is something that civil society around Europe would be very supportive of. And it sounds like most of the speakers on this webinar are supportive of it as well. So I hope that that's the way we can move forward. Thank you.
Thanks, Helen. I'm going to take 2 more questions, and then we do a final round of the panelists and wrap it up. The next person on my list is Mark Damsey.
Hi there, can you hear me?
Yeah.
Daniel, thank you very much for organizing this. My questions are going to be quite direct, and I suppose more for Alemanno, who, by the way, did a great presentation, so thanks again for that. With the formation of such a body, given the lack of credibility, I have to say, our record the EU now has in countering transgressions, whether it be rule of law or just playing out corruption and cronyism. And I say that as very much an EU person myself, and as a former EU policy advisor for the Financial Conduct Authority in London. I suppose, Alemanno, one, do you think such a body could genuinely work and therefore enhance the credibility of the EU? And then my second one was really a more simple, direct one. It's really, if you have a former EU official, should they be banned from working in the private sector, in the sector which they represented the EU at all? Or should it be just for a short-term period, say of 2 years? Anyway, thank you very much.
Thanks, Mark. And last question from Jean Comte.
Oui, allô, vous m'entendez bien?
Oui.
Oui, bonjour, Jean Comte,
Can
journaliste
you
à
hear me?
contexte.
Yes, my name
J'ai une
is
question
Jean
surtout pour M.
Comte, and I
Freund
have
et
a
M. Séjourné
question,
sur la question très précise des
very
commissaires
specific
européens
question
et des
for,
nominations des commissaires européens
well,
et de
about
l'évaluation de leurs
the
éventuels
nomination
conflits d'intérêts.
and assessment of conflicts
J'ai
of
l'impression que
interest
la plupart des
for
rapporteurs en
European
AFCO
commissioners, because
penchent pour un organe
most
qui s'assurerait du
speakers
respect des
from
règles, donc
AFCO
vraiment un
would like to have
pouvoir pour
a body
contraindre
that
à l'application
complies,
des règles.
that
Or, je
ensures
crois comprendre que
rules
Jury, qui
compliance,
est associé,
whereas
penche
Jury
plutôt pour un mode, enfin, penche au moins pour les
is
commissaires
in
européens désignés,
favor
pour un
of
modèle dans
a
lequel il garderait la main
model
et la décision finale pour
for
savoir si
which
on déclare
they
ou pas un
would
conflit
still
d'intérêt
have
sur les
the
commissaires.
final decision,
Je voulais
at
savoir comment vous
least
voyez la
for
question,
commissioners.
si vous
So I
pensez que les
would
deux
like
modèles sont
what you think
compatibles ou
about
pas.
that, if you think that
Et
the
puis
two
plus généralement,
models
savoir
are
si vous pensez que les
compatible.
commissaires européens
And
sont
I
un cas
would like
très à part dans
to
ce
think that
sujet-là, ou
European
pas spécialement.
commissioners
Merci
are
beaucoup.
really a case apart, a different kettle of fish. Thank you.
Okay, I'm going to start with a few answers from my part. So one question was asked about revolving doors and whether people should not enter the private sector. I mean, I think that most of the rules on revolving doors, particularly for EU commissioners and for former staff, I mean, you can discuss about the length exactly of the cooling off period, but in principle, the rules there are good. It's not about a general ban of work, right? People should be able, once they leave a political position or even quitting their fonctionnaire or their civil servant role, should be able to work. That's a fairly fundamental right for everyone to exercise work. What this is about is preventing conflicts of interest. So that needs an examination of individual cases. That's precisely why I'm so much in favor of this ethics body, to judge on those individual cases, and then to either impose restrictions where appropriate, or to prevent certain new employments when the risk of conflict of interest is too high. And I generally agree that a cooling off period can make sense, particularly when people, change to an entity that they have previously regulated, or when there's too close contact between the two, or even something, I mean, the case that we had with Gerhard Schröder in Germany, that when in office, he approved the construction of a certain pipeline, and then after leaving office, joined that pipeline, basically created his own new follow-up job, and I think that's really quite problematic. So cooling off period where appropriate, general ban on switching sides, so that the case of Gerhard Schröder, even after 2 or 3 years, would not be this concrete case. But no general prevention from working, and obviously any restriction on work. So when people do face cooling off periods, I think it's normal that they get some financial compensation for that. So I think a transitional allowance or some form of payment and cooling off periods should be coupled together. Unfortunately, for Jean Comte, Stéphane Séjourné, I think, has had to leave us, so I can obviously not speak for him. My own preference is clearly that the body could decide on advice or sanctions itself. If that if the discussions that we're having among the shadows and among members in the parliament over the coming weeks and months show that there is no majority for that in the House, obviously we can discuss a better way of making a recommendation more binding than it currently is in the existing structure of the advisory committee, for example, is a plan B, so to speak, but that I wouldn't favor, at least in the first round of discussion, let's say. Alberto, if you wanted to answer some of those questions as well.
Yes, thank you. Mark asked a question about basically how those instances of ethical violations or perceived violations affect the EU. I think it's important to realize that it is not only the EU reputation that is damaged as a result of Mr. Barroso joining Goldman Sachs, but it is actually further amplified by the inability of the European Union or a willingness to go after him. This is a point that Mr. Pisapia made earlier on that I think is very important and should actually call us for action. So the EU has an urgent need to fix this internally, and the ethics body is not set to gain public salience as such. As nicely reframed by Stéphane Séjourné, the idea is really to create a body which is advising in order to prevent behavior. And when those behaviors do occur, well, it will have to sanction. And I also agree with what Helen Derbyshire has been saying about the importance of combining the two. But seeing this committee or this body as an opportunity for the EU to fix this incredible ethical deficit it has vis-a-vis citizens, I think is important, is key.
Thanks, Alberto. Giuliano?
Volevo solo tanto ringraziare
Well,
anche.
first of all, I would like to thank the interpreters who've been working for almost 2 hours. Their contribution has been key. Thank you, thank you. Well, Mr. Alemanno said that we should have a preventive assessment, and this is key. This is very important, and this is important also for the advisory committee of the European Parliament, because we receive various requests for an advice that we can give for certain behaviors that have not yet been carried out, but people who are in doubt consult us to avoid possible conflicts of interest. And I would definitely give importance to this function, because this is the most positive event of the advisory committee and the conductive members, where you have independent members, as has been shown over this 1.5 years during which we've worked together.
Thanks, Giuliano. Leila, any reactions?
I know. I'm sorry, but there was a big noise. I'm sorry, but I had to, I needed 2 devices because I have to listen to the translation from one device and to follow the webinar on the other device. So, the jury commission would be more focused than the AFCO committee. Well, I think that the jury committee, with their experience about the appointment of commissioners, and I think that it is up to us, AFCO committee, to go beyond that, and to go beyond what regards commissioners. With regard to the composition of the ethics body, first of all, as I mentioned, the civil society, in my opinion, is important. And yes, I believe that, yes, the civil society should follow the appointment of the members composing the ethics body. I think that we should go even beyond, and that the civil society may participate directly in this body with the presence of civil society in the composition of this body. This is a means to allow independence and to have the body separated from the institutions. And I would like to thank you, Daniel, for the organization of this webinar, and all colleagues who have attended this webinar, Mr. Alemanno, and all the attendees, and their contributions were so interesting. So I must say that the civil society may rely on us in order to reach the objective of an ethics body which is ambitious and effective. Thank you.
Thanks to all of you for participating. Thanks indeed for the translation that facilitates our European work. Thanks to all the team that helped with all the technical setup of all of this. I'm very much looking forward now to the actual debate on the report starting in the European Parliament in the next couple of weeks. A conversation that will continue over the next few months. So do stay tuned. If you do want to follow well, my work in the European Parliament on this, don't hesitate to sign up to my newsletter that you find on my website. If any questions remained unanswered today, please do send them by email. And we'll make sure to get them answered or to transfer them to any of the other panelists. I'm sure that's okay. And yes, thanks for joining us here today and for this good debate, and looking for the next one once we have made the first steps in putting something concrete in place.